because of the incident that occurred on last Thursday, Friday morning in Eugene, resulting in the issuing of a DUI and reckless driving charges. And this does iterate the idea that he has not been convicted of any crimes for this, as far as we are aware of, and the court has not entered into a judgment. But still, is there the situation, and I think this is the insurance situation that I asked JJ about. Even if we are simply aware of some of these issues, the county could be liable for any events that might take place as a consequence of that event. And if we have not protected the county in some way, then we could be liable. The county could be liable. So that's really the background of this, the report. And then the recommendations are that we would tell the county personnel are directed to not to provide vehicles to Commissioner Hare. 2, the county personnel as identified by the Director of Public Works are directed to drive Commissioner Hare when he is traveling on official business. And the reason for that is interesting. I was not aware of this, but it was brought up that even though he might be driving his personal vehicle, if he is involved in county business, the county also then is liable by extension. And that was, and correct me if I'm wrong, JJ, but that's a simple explanation of how this works itself out.
Yeah, I mean, ultimately, if you're an agent of the county on county business, regardless of whatever vehicle you're on, and you injure someone, the odds are there will be a lawsuit accordingly.
And in case any plaintiff's lawyers are listening to this transcript, I would say that I would not sort of declare that the county would be liable, but I would suggest that it would be exposed if it's
Well, and whether or not you're found to be liable is, your costs are going to be pretty excessive because you're going to have to defend it. So even if you win, you still lose.
Well, I see what I think the legal counsel is advising is that saying that we're liable is a result of a judicial action.
Yeah.
The potential of it is,
we need to acknowledge our exposure.
Yeah.
And the potential liability.
Right.
Agreed.
And that the Board of County Commissioners has a sole authority to approve mileage reimbursement claims submitted by Commissioner Hare. And that's specified. We do that now to some degree, but not rigidly so. And this is basically saying that rigidly so, that will be done until there is some repeal of this statement report.
I think item number 2, that the county personnel as identified by the Director of Public Works are directed to drive Commissioner Hare when he's traveling on official business. Does that mean that we as commissioners, like if we were driving him to a meeting in Eugene, we don't have to be directed by Public Works because we're elected officials of the board?
But I think the idea of continuity of identity is that we would run my name and say, Rob, we are going to be going to a meeting in Eugene, and I'm taking the responsibility of making sure that he is not driving at all in exposure.
Okay. I just want to clarify that. Is that a correct
assumption?
Ideally, I mean, let's remember under the handy circumstances in regards to the public meetings laws that it's always a sensitive issue if you're going to be going to a meeting together or returning from a meeting together. There's great limitations on the discussion topics that can be involved if you're actually traveling together. So that is, I think, less than ideal for other reasons. I would probably not recommend that as being a general approach.
What I was thinking of was things like the AOC meetings and the ONC meetings, which are just commissioners. Those aren't staff. Those aren't other county employees. And any and all commissioners go to those anyway because they are professional associations affiliated. So those were the ones I was thinking about.
Yes.
Because he is on the board of both. And by virtue of being on the board of both, he would have to attend those meetings. And either one of us, even before this incident, could have attended, because it's a commission, Board of County Commissioners group, professional group, which we've done. We just attended the AOC meeting in Eugene. a couple weeks ago. So in that instance, it would be one of us going to the meeting as well, driving. So that was my question, being that he is on those boards. So. Which is, as I understand or have historically understood, did occur as far as commissioners driving together to save the fuel, to save the cost of taking 3 vehicles instead of 1.
It's fully legal to drive together. No problem there at all. Of course, the danger is that decisions cannot be deliberated upon and information can't be gathered during the process.
Yeah.
So it just needs to be. I know, and I appreciate that greatly. So I would just suggest that if you do decide to do that under the circumstances, then just keep in mind that that's another aspect to that situation.
Mr. Mathis, could I just ask you to move that your stand just out of the main walkway?
Oh, I wouldn't want it to fall over and burst into flames.
So, are we satisfied with that?
Yeah, I'm fine with that.
The format is, report and recommendation, and so I did provide signature lines. The board should decide to adopt and approve this report and recommendation.
Mr. Chair, do you need a motion?
Well, are we satisfied with this too? What it is? Do we want to add anything to it, subtract anything to it?
No, I think at this time it's succinct and deals with the issue that we have right now. So it's fine.
Do you want to address a timeline on it?
No, it says until revoked.
Is it effective immediately?
Well, it says approves, and if we sign it today, it's approved today.
Yes.
We would fill the date in.
Yeah, one thing to note as it relates to our driving policy, I brought it in, and we have a driving policy because this is what county policy authorizes you to use to drive. And it says no major violations in the last 3 years. A major violation, some of the examples that are listed are reckless driving, driving under the influence of alcohol. Both of those would classify as an unsafe driver. However, I think if in this particular instance, assuming he is found guilty, and I think at the time you have a certain time frame to go through diversion and that sort of things, and if you complete that, I don't know what the timing is on that.
A year.
Is it a year? So
you've got 3 days to enter into the program to make a decision.
So I'm assuming that Commissioner elects to do that, assuming he's found guilty. According to our policy, assuming he didn't go through diversion and have it pulled off, they would be classified as an unsafe driver for 3 years, unless, of course, they went through diversion and had to take them out. And I think upon the completion of that, they would be pulled off and they would no longer be classified as an unsafe driver.
Well, I mean, for assuming that this is approved, he would fall into that category right now, right?
Yeah.
Yeah. Okay.
But as I understand, as you stated, the diversion, if he successfully completes the diversion program over the next year, then there is no record that the court releases that.
Right.
And then that, of course, would not apply.
Okay.
Okay.
The other thing to consider, this is the board's recommendation, as an elected official, the board as a whole has an authority to, has oversight over all equipment and expenses, but not over the actions. So if an elected official elects to drive themselves places, I don't know if the board as a whole can do anything.
I mean, where does this liability string, how far out does that stretch, and where does it connect to if he is on, like, the ONC board, and he goes to those board meetings, and he does not claim mileage, he doesn't claim hotel accommodations, etc., and he is involved in an accident. Does that string get stretched that far of liability to the county?
Oh, it's impossible to say, and again, I prefer the exposure concept than have a sort of suggestion.
Because the county is exposed in that kind of situation.
Yes, because one never knows if a plaintiff's attorney would be listening to this sort of proceeding. down the line. Well, I mean, you're sending him on official business. It sounds, I mean, you may or may not be sending him in the future on official business.
And that was sort of the backwater of this question, too, in that sense, is how far do we go, or how far should we go to protect the county from exposure, as far as notifying OMC that he is not our representative anymore, or he is the whatever other committees he might be involved in. What I've provided you here is an option that would enable the county to transport him to and from locations for his official business. It would involve a driver. So I think that is something that you do have. If he is driving on his own, then yes, it's my assessment that if on official business, engaged, in official business at the time of the driving or the collision or the disaster or whatever may occur, then our exposure would definitely be implicated there. Not admitting liability, but our exposure would be increased. I think we would have significant exposure.
I look at this number 2. It says that county personnel, as identified by the Director of Public Works, are directed to drive Commissioner Hare when he is traveling on official business. So the inverse of that is that he's not to drive on official business unless he has a driver.
I don't know if...
Is that what that...
I think that's about right. That's how I'm...
Decides on his own accord in violation of his... Because that would be a violation of his diversion program, unless they could give him the authority to drive to and from work, and the court can decide that he can drive to and from work. But to go out on official business,
but I think that's work business.
Yeah, but to go on official business, this right here in number 2 says that someone has to drive Commissioner Hare when traveling on official business. So if he decides he's going to get in his car and take off and go on official business, then he would, the exposure to liability would be subject to interpretation by a court if it came to that.
I think you've done about all you can.
Yeah, we've done about everything we can here by saying he can't do official business unless he has a driver.
Okay.
So.
You're saying something that you did?
I think you just addressed it.
Okay. As all things go, I'm sure there will be some permutations of this impact of this event that we'd have to deal with when they arise, I'm assuming. But there's nothing else that you are aware of now that we need to be more sensitive to or address or provide exposure coverage or any such thing as that?
I don't think so. And certainly JJ could weigh in, but I mean, the county does, of course, provide, I think, through its health insurance program, substance abuse treatment coverage, right? Mm-hmm. And so I think that's publicly available. And that's probably about the extent of it in terms of the county's official action.
Okay. It would be advantage. It would be a plus then if we encouraged Commissioner Hare to investigate the county's provided remediation program, or
I think that would be the place of HR. It's not our place to do that, but that is, we can discuss the availability of the benefit, which we've just done, but the benefit's there, but it's not up to us to offer the benefit or implement the benefit, or that's up to
I'm happy to send them some correspondence and make them aware that this is an available benefit to him if he chooses.
Which you would do for any employee.
A public official. It's available to all employees. It's not just it's not just the board.
Which I think you'd understand. I think we would encourage you to do that.
I'll definitely do that. I can say that I'll have no knowledge whether he chooses to use that.
Oh, sure.
It's a confidential. It's a confidential service. Mm-hmm. So.
Right.
Okay.
But sometimes when they're in a situation, they don't think about what might be available. Even though they know at the time they sign up, for employment. But when situations occur, they may not remember.
I'll send them a correspondence with a link to the information.
Yeah.
You ready?
Well, okay. Yes, ma'am.
Okay. I move that we adopt the 5 advise the Office of Legal Counsel, Wally Hicks, that on the use of county vehicles.
Okay.
December 15th, 2015.
Moved. I second that. Any other discussion on it?